President.
Senator from Washington.
Mr. President, I come and I join my colleague from Oregon on the floor this evening. Thank him very much for his comments and his hard-fought efforts to try to illuminate the issues that are before the American people in this nomination that we are going to be voting on. As nightfall does not come at once, neither does oppression. In both instances, there is a twilight that we all must be aware of change in the air, however slight, lest we become unwitting victims of the darkness. Those aren't my words. Those are the words of the late Supreme Court Justice William O. Douglas. Yes, that's right, I quoted William O. Douglas, not because he was from Yakima, Washington, or via Maine originally, but because I wanted to bring up the rights of Americans that could be undermined by a confirmation of Judge Kavanaugh to the Supreme Court. That is because for generations, the United States Supreme Court has been an institution that affirmed rights of Americans and moved our country forward, especially when we needed it most. In 1954, it made a landmark decision to end segregation in our schools and to rightly give access to equal education. In 1964, it recognized the rights of privacy and the ability to access contraception. Hard to imagine today that in this era that we needed that fundamental right and that had previously been blocked, and yet it was. And in 2015, the Supreme Court upheld the fundamental rights of marriage for same-sex couples, that they had equal protection under the law. Yes, these are rights that have been decided by our court and have moved our country forward. So when those who say that President Trump nominated Judge Brett Kavanaugh to the Supreme Court because he was on a list of an organization that wanted to see the literal text of a statute of over upholding the hard-won rights of all Americans, I became very concerned. When it comes to the rights of consumers, healthcare rights, environmental laws, privacy rights, labor rights, I want to know where a Supreme Court justice is going to be in upholding those hard-won rights that Americans and our societies have pushed forward on for decades. And in this case, he will be replacing a justice that has been a key vote on many of those fundamental rights in America. So I definitely expressed my opinion that I did not believe that Judge Kavanaugh would protect those hard-won rights, and concerned that he does not have a judicial philosophy that is in the mainstream views of America. He has the most dissents of any judge on the D.C. Circuit. So literally, that's like saying he's dissenting even with the most conservative judges, he's still dissenting. So I don't find those views in the mainstream views of Americans. But let's just take one example, healthcare. More than 3 million Washingtonians in my state have pre-existing conditions such as diabetes, heart disease, or asthma. And Americans don't want to be discriminated against because of their medical history. More than 75% of Americans support the pre-existing conditions that have been put into law under the Affordable Care Act. And these protections that help them from having medical debt and uncompensated care and all of these issues are very important for us to continue to protect. In 2011, Judge Kavanaugh refused to uphold the constitutionality of the Affordable Care Act, and he has criticized the Supreme Court's decision to uphold parts of that law. In his confirmation, he once again refused to say if these current protections for Americans are constitutional. His record suggests that he will not defend these protections or Congress's clear intent in writing them. And it's not just some theoretical issue. These protections today are being threatened in the courts. They are being threatened by a group of Republican attorney generals who are trying to get a federal court in Texas to strike these protections down with the health care law And the Justice Department here has decided to join those states in asking the courts to strike down these pre-existing conditions and protections. So this case is definitely working its way through the court system and could likely end up before the Supreme Court. Some have suggested, well, don't worry about that. Don't worry about that, because Justice Roberts, he'll uphold the health care law, and he will be the swing vote, and Judge Kavanaugh's appointment to the Supreme Court is irrelevant on this point. Well, that is wrong. First, you really can't count on Chief Justice Roberts in upholding the Affordable Care Act. In fact, that's what the attorneys general are arguing, that basically his previous decision is help in striking down the law, and that there are other times and circumstances now, because the federal government isn't fighting to protect the Affordable Care Act, which it did in previous administrations, that there is no guarantee that Justice Roberts will rule in favor of the law. And there are other aspects of the Affordable Care Act that he's also sided against. So to think now that this fundamental right that has been so hard fought for so many people, I can just tell you in my state, I've been to hospital after hospital and healthcare facility after healthcare facility. The doctors say to me they can't even imagine the time of what it's going to be like to go back prior to pre-existing conditions. It has become such a norm to make sure that they are covering people that they couldn't imagine that kind of discrimination today. And yet, when it comes to reproductive rights, those are under threat as well. In 2017, Judge Kavanaugh suggested he supported Judge Rehnquist's dissent in Roe v. Wade, which called the landmark decision a free-willing judicial creation of unenumerated rights that were not rooted in the nation's history. Now, as somebody who sat on the Judiciary Committee for the first 2 years that I was in the United States Senate, I guarantee you I asked every judicial nominee whether he believed in the penumbra of rights guaranteed in the Constitution for the rights of privacy or he didn't. And the reason I did that is because those who really don't believe that Roe was rightly decided believe that those rights aren't being enumerated and could overturn them in the future. So while Judge Kavanaugh may now claim he believes Roe is settled law, records from his days in the administration raise doubt to that fact, and perhaps more importantly, during his confirmation hearing, he refused to say whether it was wrongly decided. Well, why is that important? Because in the near future, if a majority on the Supreme Court decides that it was previously wrongly decided, they can just overturn it. If Judge Kavanaugh does not believe the Constitution gives women the right to make decisions about their own body, then whatever assurance he gives us now about precedent are hollow. This is why it is so important to people in my state. We voted in 1991 by an initiative of the people to have this right in our state law. And we in the state of Washington and millions of women want to see every woman in America have these same rights. So I take President Trump at his word when he said he was going to put a nominee onto the court that automatically would overturn this. These justices, Roberts and conservatives like Alito and Thomas and Roberts and Gorsuch, would now be joined by Kavanaugh and overturn this right in a 5-4 decision. And even if they don't fully overturn it, they could effectively undermine its protection piece by piece. Chief Justice Roberts, for instance, has repeatedly upheld restrictive limits on reproductive rights. These justices have already proven themselves very willing to restrict access to safe and legal abortions. So, as I said, my state decided by the people that they wanted to protect this, and I'm here to help and defend that for other women in the United States of America. If Judge Kavanaugh were to serve a lifetime appointment on the court, he could also pose threats to the rights of the LGBTQ Americans, not just in my state, but across the country. The Supreme Court will likely hear cases that impact this community. There are cases pending, such as the Arlene Flowers case in the state of Washington, where a florist refused to provide services at a gay couple's wedding. The court could also likely hear arguments on the President Trump's discriminatory ban on transgender service members. The rights of LGBTQ Americans are at stake with Judge Kavanaugh on the bench because his broad view of religious freedom could provide a license to discriminate against these individuals. Judge Kavanaugh's record also suggests he will be hostile to the protection of other privacy rights. In 2015, after it was revealed that the National Security Administration, NSA, had been collecting Americans' phone records in bulk without warrant, Judge Kavanaugh decided the national security needs outweighed individuals' right to privacy. He supported expanded warrantless surveillance by the government. What's more, Judge Kavanaugh has ruled in favor of restrictive voter identification laws, raising concerns he would support scaling back hard-won voting rights. The right is sacred in our country, and the last thing we need is a Supreme Court that would refuse to defend it. I'm also concerned about his precedent in important issues that could affect Native Americans. Native Americans need to have their sovereignty recognized and their rights protected. In this term alone, there could be 3 cases before the court, and at risk are some of the most basic tribal rights in our country. So Judge Kavanaugh's positions found in his own writings before he became a federal court judge indicated that he did not take seriously the constitutional status of tribal governments and the solemn obligation of the United States when it entered into treaties and agreements with tribal and Indian people and Alaska Natives. So time and time again, these issues are before us and before a court. And that is why, as I said, I believe in a court that protects these hard-won rights. I know that textualists will tell you something differently, but where would we be on just the basic rights to contraception if we didn't have a court that looked at the unenumerated rights in our Constitution? Where would we be for equal access to education? And now where will we be on the future rights of privacy that need to be protected in the United States of America? Time and time again, Judge Kavanaugh has favored big companies over everyday Americans, using a twisted logic to defend big corporate polluters. Kavanaugh seems to have a particular animus against the Environmental Protection Agency and their efforts to follow Congress and the direction that has been given in law to reduce air and water pollution. That is a direct affront to the leadership of people like Ed Muskie, who led Congress in its effort to act the Clean Air Act in 1970 and control pollution, and in 1990 when Congress amended the law to combat acid rain, ozone depletion, and auto emission. And since then, the U.S. Supreme Court has upheld the Clean Air Act numerous times. In 2007, in Massachusetts case, the Supreme Court ruled that the U.S. Environmental Protection Agency has the authority to regulate greenhouse gases under the Clean Air Act, and Justice Kennedy, who Judge Kavanaugh will replace, provided the 5th and deciding vote in that decision. But as Kennedy's replacement on the court, the government's ability to mitigate climate change could be lost. That would mean everything from not addressing these impacts that we're seeing on our coastal communities to what we're seeing in damage on wildfires. And it could mean the report that was done by the Government Accountability Office that said climate change impacts were costing us over $620 billion every 10 years, that those will continue to be ignored. We want a Supreme Court justice who is going to follow the law and basically abide by what Congress has said and uphold that, and that is what the court has said as well. Judge Kavanaugh, though, said he didn't think that EPA had the authority to regulate air pollution across states. The U.S. Supreme Court reversed his decision and opinion. In a 6-2 decision, they concluded that Judge Kavanaugh had improperly applied his own policy judgments rather than the plain text of the statute written by Congress. That is what the Supreme Court said in reversing him. So, I'll say it again. The United States Supreme Court said Judge Kavanaugh used his own policy judgments rather than the way the law was written by Congress. So yes, I have concerns that his views are not in the mainstream of America and of judicial philosophy when it comes to protecting our environment. In another case, he opposed the EPA's interpretation that it can control pollutants because he thought that the terms of the Clean Air Act didn't include that. He also sought to limit their authority to protect Americans from greenhouse gases. In a 2013 case, the Center for Biological Diversity, Kavanaugh said that the Clean Air Act does not even cover carbon dioxide at all. In fact, he ruled to weaken environmental protections in 89% of the cases that have come before him. So I do not call that in the mainstream views of judicial philosophy. So tomorrow, we will have major issues before us as this vote takes place. When it comes to whether you're siding on behalf of the American worker or large corporations, I too have concerns. In a 2015 case, he overruled the National Labor Relations Board, siding with a hotel that had requested police officers to issue criminal citations to union demonstrators who were legally protesting. And in a case, he banned employees from interaction with customers or who worked in public forum wearing union shirts that said certain words on them. So the NLRB found that the employer committed an unfair labor practice, but Judge Kavanaugh disagreed, concluding that the union members did not have a right to wear the shirts because the company believed they would be damaged. I can tell you, because I am so concerned about the information age that we live in, that when it comes to these issues as it relates to protecting consumer rights, there's no bigger consumer right than it exists in protecting those on the internet with the right to access and information. We cannot have a two-tiered internet system in which these rights are not protected by a court. And in this case, Judge Kavanaugh wrote that the FCC did not have the right to regulate broadband as common carriers. Instead, he made it clear that he believes that broadband cable companies should be able to control your internet experience as they see fit, So part of his flawed analysis rested on the idea that the FCC was purporting to do protecting consumers was a type of rule that was so consequential that it could only stand if Congress bestowed clear and unambiguous authority on the agency. This is in contradiction to the Supreme Court's own precedent, which had determined the FCC did have the authority to decide whether and how to regulate broadband. The other part of his faulty analysis rested on the view that cable and broadband companies that operate these pipes that serve on as a ramp to the internet have First Amendment rights, and they should be able to access those rights and deny or limit consumers' access to content. I guarantee you, saying that First Amendment rights by cable companies to charge whatever they want to charge you for the future is not in the mainstream view of judicial philosophy or what the American people have come to expect. So let me say again, these important issues are not part of Judge Kavanaugh's ways to protect these rights of health care, of the environment, of privacy, of consumer rights, and the things that we take so dear that we have all fought for, legislated for, and had previous courts upheld and make sure are preserved. So I'm not buying the notion that a strict textualist is the way to go. I believe my colleagues have every right on the other side of the aisle to agree to that, but I would ask them, how are you ever going to move America forward in decisions like our desegregation of education or on contraception or on these other privacy rights if you don't interpret the Constitution to today's day and needs? And I would say now, while the biggest threat we face is an overreaching of an administration that every single day does something not to comply with the law as it is written, the president just issued an executive order weeks ago that basically said he didn't even have to worry about administrative law judges. The agencies could hire their own, which means an agency can decide whatever rule it wants and just hire an administrative law judge and make it so. Those aren't in the mainstream views of America. And is this judge going to challenge the president on that? Or is he just going to say that he agrees with the President of the United States on what, as one White House counsel from the Nixon administration said, Judge Kavanaugh, if confirmed, quote, will be the most pro-presidential power Supreme Court in the modern era, end quote. Well, I can tell you this, if those on the other side of the aisle are promoting this nomination because they want a rubber stamp on the Trump administration, we will fight you every step of the way. The Supreme Court is supposed to be the impartial arbitrator, the one that, even though we have different Congresses and different views, interprets the law over a period of time, that does not make those political decisions, but makes the impartial decisions. And to have somebody on a court now where every day an administration is not following the rules of the law and basically subverting them, it's a time where we need a Supreme Court to stand up and do their job and hold an administration accountable. I'm sure it's not a pleasant activity to have anybody hold an administration accountable, but this is an important time for checks and balance in the United States of America. And I don't believe that these rights of individuals or the rights in protecting us from the overreach of this administration will be defended by this nominee. Now, I know a lot has been said today about what the process for this nominee has been before the courts. I know there's a lot that will continue to be discussed after this day about how this institution handled this situation and accusations against Judge Kavanaugh. All I can say is that we need to do better. We need, as an institution, to do a better process in evaluating these situations and how to make them less partisan. But I will tell you this, I found the testimony by Dr. Ford credible, and that this institution's latest avenue of saying, well, it must have happened, it just wasn't him, is another example of denial of information instead of getting to the truth of the situation. We have to do better because we're an institution that's supposed to lead on this issue. We're not supposed to be an institution like the other institutions we've seen sweep these allegations under the rug only to come back at some point in time when there are 300 cases or 400 cases or X number of people who've been impacted, and thereby they all have basically crested the wave over the allegations that have been denied and denied and denied and denied. This institution has to figure out a better way to lead on this issue, and I plan to continue to work with my colleagues on both sides of the aisle to help us continue to focus on this. So many people in America are counting on us. So many women in America are counting on us. So many tribal women are counting on us. The statistics are just too high. To leave a nominee on the court with a doubt of this investigation and this situation not rendered to a point where more people felt that the information was fully investigated. We have to do better. We are going to be challenged as we move forward. As I said, I don't believe that Judge Kavanaugh's nomination is in the mainstream of judicial philosophy in the United States of America. That is why I'm not supporting him. I didn't support him the first time he was nominated for the court because I had doubts that he would be that individual who put those political partisan things aside and be that impartial justice. So I didn't make a decision right away. I went back and researched his record. I looked at these decisions on these basic rights that so many Americans are counting on. And I can tell you this, these rights, you cannot count on Judge Kavanaugh, and therefore he does not get my advice and consent to move forward to the Supreme Court. I thank the President, and I yield the floor.